Hello everyone, this is Mr. Lipchick, and our discussion today is going to be on challenges to Americans' civil liberties. One important challenge that has come up, and it's a source of a great deal of debate, is the debate over affirmative action programs. In the 1960s, the federal government created the policy of affirmative action in order to make up for past discrimination against certain groups. Affirmative action is defined as government policies that directly or indirectly give a preference to minorities, women, or the physically challenged to make up for past discrimination. Most affirmative action programs are mandated by the federal government, while others are done by institutions voluntarily. Affirmative action programs apply to hiring, promotion, admissions to school, and awarding of government contracts. And affirmative action has become a source of debate, as many feel that using race under any circumstance, even to make up for past discrimination, is wrong. And it has been challenged in the courts, as affirmative action cases have involved admission to prestigious schools. Court cases have sometimes resulted. In Regents versus University of California versus Bakke in 1978, a young man, Bakke, to the right, applied to but was rejected from the University of California Davis School of Medicine, even though he was highly qualified. When he learned that certain minority students were admitted on the basis of a quota system, he sued and asked for immediate admission to the medical school. Bakke won the case because it was ruled that his race, in this instance, prevented him from being admitted to the school, violating his 14th Amendment rights to equal protection. Bakke had been a medic in the Vietnam War, very accomplished young man, and he was head and shoulders above most of the candidates. In Grutter versus Bollinger in 2003, the Supreme Court upheld the University of Michigan admissions policy that gave preference to minority applicants. In this instance, affirmative action was ruled to be legal because race was treated as a plus factor, taken into consideration with all other qualifications. So in other words, all things being equal, they considered race. The Supreme Court's attitude towards affirmative action in areas outside of education has been less clear, however. In Aradan Constructors Incorporated versus Peria in 1995, the court overturned earlier decisions supporting affirmative action, ruling that they are unconstitutional as they classify people by race. The debate on affirmative action continues between two opposing schools of thought. One feels that affirmative action is necessary to accomplish a valid social goal of increasing advantages for women, minority, and the handicapped. Another feels that by accomplishing the social goal of affirmative action, society creates reverse discrimination and prevents qualified applicants from achieving their goals because of their race, gender, and other descriptors. Discrimination against women. Women obtained the right to vote, suffrage, in 1920 through the passage of the 19th Amendment. Passage of the amendment, however, did not prevent workplace and other forms of discrimination against women. It did, however, give them a chance to achieve some of their goals through the political process. Women, before and since the amendment, have been involved in a continuing struggle to obtain equal rights. In Reed versus Reed in 1971, the Supreme Court ruled that a law that automatically preferred a father over a mother as the executor of a son's estate violated the Equal Protection Clause of the 14th Amendment. It created the reasonableness standard, any law that classifies people on the basis of gender must be reasonable, not arbitrary, and must rest on some ground of difference. And it must serve important governmental objectives. In 1977, the court ruled that treating women differently from men, or vice versa, is unconstitutional when based on no more than old notions about women and the role typing society has long imposed on women. The substantial interest standard was thereby created, which says the court has allowed some distinctions on gender when related to an important government objective. The Supreme Court has barred the following types of gender distinctions. States cannot have separate ages for adulthood for men and women. States cannot set different ages for the purchase of alcohol. States cannot exclude women from juries. Employers cannot require women to take maternity leave from work. They used to do that with teachers. Girls cannot be excluded from Little League baseball teams. Private and community service clubs cannot exclude women from membership. And employers must pay retirement benefits equal to those of men for women. And states may not bar women from state-supported military colleges. The Supreme Court has permitted the following actions based on gender. All boy and all girl public schools that are voluntary and of equal quality. States awarding property tax exemptions to widows and not to widowers. Prohibiting women from working in all male prisons. And barring fathers from the delivery room at hospitals. Starting with the Civil Rights Act of 1964, the laws have strengthened discrimination protections for women. In 1972, the Equal Employment Opportunity Act was passed, which strengthened laws banning discrimination in pay, promotions, hiring, firing, and working conditions. And the U.S. Equal Employment Opportunity Commission was established to enforce them. In 1976, Congress amended the Omnibus Education Act of 1972 to require schools to give boys and girls equal chances to participate in sports programs. In 1991, Civil Rights and Women's Equality, the Civil Rights and Women's Equality and Employment Act required employers to justify any gender distinctions in hiring to job performance and business necessity. Freedom of Information Act. The right of people to know what the government is doing is an essential part of democracy. In 1917, the government created a security classification system that keeps secret government files related to national security and foreign policy. In 1966, Congress passed the Freedom of Information Act, requiring the federal agencies to provide citizens access to public records on request. Exempted are defense information, confidential personal and financial data, and law enforcement files. The Sunshine Act of 1976 opened many government meetings to the public. The law applied to 50 agencies, boards, and commissions. School boards are one example. And 1 week's minimum notice must be given of meetings to be held. And if a meeting is closed for an important reason, a transcript or written record of the meeting must be made available. Right to privacy. The Supreme Court case of Griswold versus Connecticut in 1965 established that privacy is a right protected by the Constitution. It ruled that the First, Third, Fourth, and Fifth Amendments create an area of privacy that is protected by the Ninth Amendment. In subsequent decisions, the court has recognized the right to privacy in personal matters such as child rearing, abortion, and personal relations within the home. The court has ruled The right to privacy is limited, however, when the state has a compelling need to protect society. Current privacy issues. Issues involving privacy on the internet are of concern as the public government agencies practice data mining. Using sophisticated software, government agencies are able to monitor email transmissions and capture data on many websites. And private companies mine personal information, such as phone numbers, purchases, and addresses, and then sell it to third-party marketing firms. The USA Patriot Act was passed in 2001 after the 9/11 terrorist attacks. It allows wiretapping and reviewing of private records without probable cause. Something to think about. Some of the act has been ruled unconstitutional, but some of it is still in force. And the debate over this act centers around whether surrendering privacy rights is justified in the effort to stop terrorism. That concludes our discussion on challenges to civil liberties. I appreciate your attendance and look forward to seeing you in the live lesson. Have a great day.